Today I'll be talking about a slightly controversial topic which relates to division of patent applications under the Indian Patents Act, and I'll be discussing what is the current legal position in India as regards division of patent applications. So there have been several decisions by the IPAB on the aspect of division of patent applications under section 16, but recently there was a decision by the Delhi High Court on this aspect, providing more clarity on how and when you can divide a patent application into several divisional applications. So today I'll be discussing that, how the jurisprudence has evolved in respect of division of patent applications, and also what is the current legal position in view of what the Delhi High Court has said. So I'd like to begin with a disclaimer that though I do not agree with the views given out by the Delhi High Court in respect of the provision, because in my opinion it is very restrictive, but this video is not directed towards a critical analysis of that judgment. I'll only be dealing with how the legal position has evolved and what is the current legal position regarding division of patent applications. So the provision of division of applications is provided under section 16 of the Patents Act. Before that, please make a note that the provision does not as such talk about a divisional application. It only talks about division of application. So there is a common misconception that section 16 only talks about divisional applications, but probably I'll deal with this in another video as to how section 16 should have been interpreted. But as of now, as I said, we only dealing with how the court has dealt with it. So I'm restricting myself to what the act says. So section 16 subsection 1 provides that any person who has made a patent application under the Indian Patents Act, he can anytime before the grant of the patent on his patent application can file a further application if he so desires, or with a view to remedy the objection raised by the controller on the grounds that the claims of the patent application that he has filed relates to more than one invention. So there are plurality of distinct inventions in the patent application that he has filed, and thus he can divide his patent application into several other applications. And if you would note, the provision says that the further application could be filed in respect of any invention that has been disclosed in the provisional or the complete specification. So for easier understanding, the first patent application that an applicant has filed would be referred to as the parent application, and any further applications that we file or we derive out of the parent application would be referred to as the divisional application, as has been done by the IPAB and the court. Subsection 2 further provides that the division application derived out of the parent application should not have any matter which is not in substance disclosed in the complete specification of the parent application. And subsection 3 broadly provides that there should not be an overlap of claims in the parent application and the divisional application. So the claims of the divisional application should relate to a different invention as compared to the claim of the parent application. This is how the courts and IPAB have interpreted subsection 3. Coming to how the jurisprudence has evolved regarding section 16, the first notable decision in respect of division of applications was given by the IPAB in 2011 in the matter of LG Electronics versus the Controller of Patents. So what happened here was the parent application was abandoned by the applicant under section 21(1). So he didn't file a response to the first examination report, and thereafter filed a divisional application with the same claims which were there in the parent application. And thus, when examining the divisional application, the Patent Office rejected the divisional application and treated it as an invalid application. For sake of brevity, I am not going into the entire analysis. Broadly, the IPAB read section 10(5), which says that the claims of a complete specification should relate to a single invention or a group of inventions that are linked together by a single inventive concept. So reading it with section 16, the IPAB held that what is required for filing a divisional application is that there should be a plurality of inventions in the parent application. The IPAB, however, also said that divisional applications could be filed voluntarily by the applicant for distinct inventions that are disclosed in the parent application. So the basic crux of the decision was that there needs to be distinct inventions disclosed in the parent application. You can file a divisional application out of the parent application to cover those plurality of inventions. So this remained the legal position until 2020, wherein the IPAB further restricted the legal position in ESCO Corporation versus the Controller of Patents. Here, the applicant filed voluntary divisional applications with the claims that were not identified by the controller as distinct inventions. Now, if you remember, the LG matter said that a divisional application could be filed for distinct inventions which are disclosed in the specification, but here the condition was different, as the controller had not identified those inventions as distinct inventions, and thus the divisional application that was filed with those purported distinct inventions was rejected as being invalid. So just justifying its stand, the IPAB held that the LG decision requires that the plurality of distinct inventions should have been claimed in the parent application. To support its stand, the IPAB read section 16 subsection 2 and said that it provides that a divisional application cannot have any additional claims over what were filed in the parent application, and this means that no new claims could be introduced in the divisional application. So what it meant was that you can file a divisional application out of a parent application, but the claims of the divisional application should have been claimed in the parent application and it should not have been only disclosed. So you can only file a divisional application in respect of the claims of the parent application which may have been identified as distinct invention or which could be considered as distinct inventions. Coming now to how the Delhi High Court has interpreted section 16. So to appreciate the court's analysis, I think it would be better to first go through the facts of the case. So there was a parent application that was filed originally with 19 claims, but those original 19 claims were amended at the time of filing the response to the first examination report, and all claims were deleted except for 3 claims that were retained in the parent application. After filing the response and before the grant of the parent application, the applicant further amended the claims so as to add use claims. However, this amendment was rejected by the controller under section 59 based on the ground that the claims that were amended were going beyond the scope of the original claims. So what the applicant had done was there were use claims which were converted to a product claim. This was opined to be beyond the scope of the original claims that were filed, and thus the amended claims of the parent application were rejected. So before refusal of the parent application, the applicant also filed a divisional application with almost the same claims as there were in the amended parent application. So during examination of the divisional application, the same was refused as well, and the controller gave the ground that the claims that are being covered in the divisional application were already refused under the parent application as not being allowable, and so you cannot file a divisional application for the same claims which have been rejected in the parent application. So for its analysis, what the court did was it perused the complete specification of the parent application and obviously the divisional application, because the complete specification almost remains the same except for the claims, and it found that there were no product claims in the original claims. So as I said, there were product claims being covered in the divisional application, and the court found that these product claims did not have any support in the original claims that were filed. The court also took a note that claims 1 to 17 of the divisional application were reflected in some form in the amendments that were made in the claims of the parent application, and claims 18 to 25 were completely new. Those were not supported in the claims of the parent application. So the court considered a question whether a divisional application can be filed for claims which do not form a part of the original claims of the parent application. So for its analysis, the court read into section 10 subsection 4, section 10 subsection 5 and section 15 and 16 conjointly. So based on its analysis of these sections and a reading of the legal position that it existed, the court held that a divisional application can only arise from a patent application that contains plurality of inventions. The court then considered how do you consider whether there are plurality of inventions in the parent application. So the court said that you must look towards the claims as the claims identify what the invention is, and this is provided under section 10 subsection 4, which says that the claims define the scope of protection that you are seeking. Also, the court upheld IPAB's ESCO ruling and said that the plurality of invention should exist in the claims of the parent application, and it is not sufficient if there is only a disclosure of that plurality of inventions in the description. So the court said that what is not claimed is considered as disclaimed. So if you have not claimed anything that has been disclosed, it would be considered that you don't want to claim it, and you can only divide your parent application to derive a divisional application if distinct inventions are claimed in the claims of the parent application. So coming to the facts of the case, the court said that there are no product claims in the parent application even though it is disclosed in the specification, but since they haven't claimed it, it is considered as disclaimed, and thus a divisional application filed to cover those products cannot be allowed. So to summarize, the legal position is that a divisional application can only be filed if there are plurality of distinct inventions in the claims of the parent application. So you can keep some of the claims in the parent application and file one or more divisional application for the distinct inventions that are there in the original claims of the parent application. So this is all about the legal position that exists in respect of divisional applications or division of patent application, as you may call it. If you have any questions regarding this particular provision or regarding how the court has interpreted this particular provision, please drop them in the comments box and I'll be happy to to answer those. If you have any specific comments, please do share them in the comments box. With this, I end my talk. Thank you very much for your time.